The Gauteng Education Department has lost its constitutional court battle against Hoërskool Overvaal. This after the Afrikaans medium school declined to enroll 55 English-speaking pupils earlier this year. The Constitutional Court has found that authorities failed to provide that other nearby schools didn't have enough space before enrolling the pupils at Overvaal. The department spokesperson Steve Mabona joins me in studio. Steve, good evening. It looks like this ruling has forced the department and officials at Hoërskool Overvaal to finally work together.
Look, working together started a long time ago. Like as you said, that for us it was more about the principled decision that we wanted. Because you know that at the High Court we have said that there's so many things that happened, during that process. And we felt that probably a different court might come to a different decision. But, the Constitutional Court confirmed that administratively we did not do due diligence to our work as far as confirming that probably the other two schools had capacity to accommodate those learners. But remember, for us, what we said, it was more about accessibility. Because we said, when you look at the proximity of, the residents who wanted to access that school, through the application system, they were accessing the school which was very close to them, and we felt that they need to access the school. But we had to then make sure that we place them in the other schools. But we have started already conversing that how we're moving forward. Hence, we've delayed the process of admissions for 2019 so that we verify lists and make sure that we're not back in the same situation that we found ourselves in.
That administrative process was something that the department, and many had raised this at the time, that the department did not pay enough attention to issues such as there were no English teachers at that school, and yet the department insisted that these pupils should be accepted, despite the fact that the school said it didn't have enough budget to accommodate it. And the Constitutional Court's ruling confirms that. So what are the lessons that you're drawing out of this?
Look, but the Constitutional Court did not go into the merits of the school, whether there were enough teachers. Because remember, we offered as the department, we said, we have a budget, we're going to appoint those teachers and make sure that we avail additional budget as per the school requirement. But the issue was, I think, more consultation. There was no enough consultation, and we have learned from that.
And also not enough time, that the time frames given were simply too short.
Look, when we were at that level, we felt that we were ready to make sure that we give them that resource. Hence, we have committed that we'll give them a resource. But because they said they don't have capacity at the school in terms of accommodating those learners, then they said, no, we don't have capacity. But an element of Afrikaans versus English came, during the application of them saying they can't accept the learners. Hence, we felt that, look, we can't even focus on saying you're not going to accept the learners because of language. Because we said, if numbers dictates that language policy must change, definitely we must go there. We know that people are actually they're not comfortable with the fact that, demographics has changed. We don't find an area where we have one language that is spoken. It's a fact. So those parents will want to access the school nearby, unlike moving away from where they are to access the other schools.
But, and I think that obviously it's two separate issues. The department has very much placed this battle, if I can put it that way, with Hoërskool Overvaal as one of non-racialism, whereas the Constitutional Court today has said it's purely part of your difficulties. They haven't dealt with the non-racialism part of it, but just the administrative issues. So when you look at it, at the end of the day, part of why it failed was due to the department, the fact that you bypassed your own processes and did not necessarily tick the boxes in the way that you needed to.
No, look, there was no process that was bypassed. You will understand that the two affidavits that were deposed by the two principals.
But the Constitutional Court said by not checking the other schools, the department then didn't look at all the options that were on the table, given the short time frames that you're also dealing with.
No. The officials did check, but the Constitutional Court says we did not give enough information to justify us saying there's no capacity at those schools. Remember, there were two affidavits from the principals who were saying we have enough space to accommodate these learners. But when we interacted with them, they said, no. We actually, we did not check with the administrators. And there were so many things that came during that hearing. Hence, we felt that, look, let's go to a different court. Because when we interacted with those principals who deposed the affidavits, they said, no, actually, we don't have capacity. Because our argument was that overcrowding should not be perpetuated. We should make sure that we avoid overcrowding by all costs. Hence, we are saying the other school cannot be changing their classes to other things, which we feel that they would have had capacity if they had not changed the structure of the school. So that was our argument. But we are saying we've started to work very well with all the stakeholders because we did not stop interacting. Remember, these are our schools, so we can't say SGB took us to court and then we stop interacting with them. We have to continue to interact with them and say, let's now go back to the schools. We went there today just to sprinkle the spirit of Madiba, a reconciliatory mood, and say we can't be saying this is not our school. Let's move forward, make sure that the intervention that was employed by other stakeholders, talking about the South African Council of Churches, they came there to assist to broker some peace. And we are actually indebted to them to say, look, that paved the way for us to can start talking to say, come 2019, don't want to find ourselves in this situation. And this, we can't take ourselves to court, and meanwhile we're supposed to be interacting with each other.
Let's move on to the issue of applications for next year. You've said that for now they've been put on hold. So what happens to those parents who need to apply for a position at the school for their children?
Look, what we did, we said, let's put our application process not on hold per se, but we said, let's prolong the date because we were initially supposed to send SMSs on the 18th of July. But we felt that, look, we need to verify. We went back, verified the list, make sure that we interact with the different schools, looking at our system because we could tell that some of the things are not going as per our plan, as per why we introduced the system. Because we don't want parents to be alienated. We don't want parents to be shortchanged. Parents must be given a fair opportunity. If you applied on time, there's no way you will be not considered. So we had to verify the entire process to say, on the 3rd of August, we will be sending SMSs to parents. They need to then go to the system and accept those offers within 7 working days, because if you don't, we'll then move into the parent that need that space.
And just to take you back to the time that we saw this initial conflict between the department and the school, it was quite emotive because, some of the issues around transformation, especially of South African schools, is very emotional. With the benefit of hindsight, do you think that the department perhaps got carried away by those emotions because it was a project that you're so invested on that you didn't do all the groundwork that the Constitutional felt needed to be done?
No, but the other elements of racialism or non-racialism, those are the things that came during the application process, if you were to recall. Because for us, remember, the SGB took us to court. We did not say, we don't want that. They said, department, you cannot place these learners. Then we said, why? Because according to the policies, we can. As the department, we can place learners. Because, like, for instance, now we're going to issue SMSs to all parents on the 3rd. Those that schools did not consider, as the department, we have a responsibility to place those learners. We'll be doing that process up until the end of October. So we said to the school, but why you say you cannot place? They said, no, let's go to court. We'll explain there. So an element of capacity, then they had to add the issue of language to say, but in any case, the language there, it's single medium. Then during our argument, we said, but you can't go there. Because we are saying the school, one way or the other, must be accessed, because these schools, they belong to all, races, they belong to everyone. So if you say you want to exclude other learners because of language, what are we saying? So that's when the issue of racialism and non-racialism came. But it was not for us to say, let's introduce it. It was there in the public space. We were attending court, and media was there capturing as per what was transpiring there.
All right, that's where we leave it for tonight. The Gauteng Department of Education spokesperson, Steve Mabona.